something that is becoming more and more prevalent in the corporations with more than one shareholder is these involuntary dissolutions. They're subject to California Code of Corporations, Section 1800. What's that mean, Dave? Okay. Basically, an involuntary dissolution is when kind of the shareholders can't get along. And there's different grounds for why a certain number of shareholders or minority number of shareholders could ask the corporation to be dissolved by the court. It's a lot like a partition action that we've talked about before, where two people that own a piece of real property together say, we don't want to own it together anymore, or one of them says we don't want to own it together anymore, and the court orders it sold or purchased by an appraisal. So that's a lot of talk to get to the meat and potatoes. Here's the meat and potatoes. One of the dangerous parts about Section 1800 is that it has what's called a catch-all provision. Catch-all provisions are like ways where the court can say, hey, it's just basically just that I go ahead and dissolve this corporation because these people aren't getting along. So here's some of the grounds for dissolution, first of all, before we do the catch-all. One of them is, you have an even number of directors who are deadlocked and business can no longer be conducted. Another reason for dissolution is that there's an internal dissension of two or more factions of shareholders in the corporation, and they're deadlocked and business can no longer go on. But now, the period for the corporation has expired, or the articles say that it can be dissolved in some way or another. But here's the catch-all, and this is the one that's becoming more and more frequent in our office. Those in control of the corporation have been guilty of or have knowingly countenanced in persistent and pervasive fraud, mismanagement, or abuse of authority. That makes sense, right? Of course, you should be able to dissolve the corporation if that's happened. But how about this? Or, and I emphasize or, persistent unfairness towards any shareholders or its property is being misapplied or wasted by its directors or officers. Now that's pretty broad. So imagine a scenario where two or more shareholders have decided to be in business together. They decide to form an entity because they thought it's a good idea. And one of them thinks it's going just great. And the other shareholder goes, boy, I can't stand being a part of this anymore. I want to sell. And after that discussion breaks down, what happens is the one who wants to sell files under that exact catch-all provision, essentially saying, hey, I feel that there's been abuse of authority and persistent unfairness towards me, and that the property's misapplied or wasted. And you can imagine the kind of things they're going to bring up. The time that the other shareholder forgot to register at the Secretary of State, or paid the taxes late, or, we got this employment action claim that came out of nowhere and it was all their fault, or any other regular kind of mistaken business things that are often overlooked that become the subject of one of these actions. So that's right, you're not stuck in a corporation forever. And so our advice in these situations, if someone says, hey, I really don't want to be a part of this, is start working together, get a very experienced accountant or business valuation expert, and make sure that you negotiate in good faith, because these are messy actions, they're extremely expensive, and in the end, if you prevail, it just makes them continue to be your partner, right? That's no good. So work diligently if you have a shareholder that wants to be bought out, and if you're thinking of forming a corporation, let's make sure we have those buy-sells in place before we get started with business, with accurate triggering events that allow for a buyout when somebody no longer wants to be part or no longer wants to pull their weight with the corporation.